In the introductory chapter to our book, we try to identify the essential problem of interaction between EU law and national laws, which the Viking and Laval cases represented and elevated to a critical level. I want to try to conclude our discussions this morning in a meaningful way by reverting to the way we theorized this particular interaction in our introductory chapter, and by briefly considering how this morning's contributions have fed into the theoretical construct which we sought to put forward. It has for a long part of the history of EU law been clear and predictable that there is enormous potential for conflict between EU law and national legal systems in the field of collective and individual employment relations. That is to say, more particularly, a conflict between national labour laws and the EU laws of fundamental economic freedoms and competition. Labour laws can be seen as enacting or protecting various kinds of labour or employment rights and protections which can be regarded as anti-competitive and curtailing of the economic freedoms of employing enterprises. It seems to us, and we put this forward in our introduction, that it's useful to think of three possible and to some extent actualized modes of relation between labour law, primarily in its national manifestations, and free trade and competition law, primarily in the EU law manifestations. We could think as a first possibility of exclusion mode, in which free trade and competition law are systemically excluded from the field of collective and individual employment relations. We could think alternatively of a possible reconciliation mode in which there is a commitment to reconciling the two bodies of law and principles and norms in the sphere of individual and collective employment relations. And thirdly and finally, as you will now predict, we could think alternatively of a third supersession mode in which EU free trade and competition law systemically prevail over the norms of national and indeed quite possibly EU labour law. The choice between these modes of relation has been over the last couple of decades now crucially challenged and focused and concentrated by the upholding of the claim of employing enterprises to post workers to other member states on the terms and conditions of the home country, thereby in various direct or subtle ways undercutting the labour terms and conditions in the host countries in the name of freedom of establishment or freedom of provision of services on a cross-border basis. It has been clear that that claim provides the basis and location in which for a potential supersession of national labour laws by EU economic freedoms and competition law. The question then is how far has that potential been realised? Briefly, I suggest that the history has run as follows in all too crude summary. There was a significant period of exclusion mode represented by the jurisprudence in and around the Albany case. I am tempted to think of the Posted Workers Directive itself as an attempt of very dubious success, but nevertheless as an attempt to move into and concretize a reconciliation mode in the to deal precisely with the posted workers' set of problems. Many of the problems we now face, of course, testify to the difficulty and lack of success of that reconciliation attempt. And VikingLaval, of course, by contrast, represented a sudden and largely unexpected plunge into supersession mode, which we've been struggling, all concerned have been struggling ever since, to contain and tame. And this is true of all the actors from all their perspectives, because everybody has seen this as an all too real problem and a necessity. So in many ways, everybody has been trying to find ways of moving back towards exclusion mode and certainly into reconciliation mode. The difficult history of the Monti II proposals, as chronicled in our book, is a vivid illustration of this essential struggle. But of course, that's only one among many. I respectfully suggest that you could view really all the chapters in our work as, in various ways, addressing that essential tension. Indeed, I feel quite confident in asserting that. And so it has been with this morning's discussions. If I may just enormously briefly touch on them. Nicola Contouris, drawing on his chapter with Samuel Engblom, sketched out a way of thinking about the recent ECJ case law in reconciliation mode, but with a labour sympathetic orientation. Jürgen Hetter, I hope I'm pronouncing names correctly, for me very nicely homed in on the exact set of tensions which I envisage as existing. He mentioned the potential utility of ideas of mutual recognition. I strongly agree with his identification of the posted worker as, in this framework, not so much an economic or social actor in his or her own right as the passive and even exploited instrument of enterprise freedom to provide cross-border services. Alan Boggs' question to Nicola brought out into the open some of the difficulties of invoking an equality principle to resolve this set of problems because of its potential to exert downward pressure on labour standards. He also usefully invoked the notion of dignity as a countervailing notion. Jeremias at that point brought into prominence the possible role of notions of abuse of law in this discussion, and Samuel Engblom the idea of a duty to protect well-functioning national institutions, perhaps an interesting form or projection of the subsidiarity notion in a way which I thought was very useful. Alan's paper reminded us of the importance of seeing the right to strike from outside the EU law context, a context in which countervailing freedoms have initial primacy, which in Alan's view they generally maintain within the compass of EU law. And he very powerfully invoked the idea of the right to strike as an ugly right, a barometer of a system's rights culture, and tells us why EU law isn't faithful to the proportionality test in the essentially balanced way in which it can be regarded as having been developed within the compass, for example, of German law. And he tells us why he's worried even about the integrated approach of EU-ILO dialogue as apparently a good way of going into reconciliation mode, but with the potential of ratcheting down of ILO, as it were, claims as a perverse consequence of that dialogue. Alan is poised between reconciliation mode and exclusion mode. And one can see why that's a place that labour lawyers naturally gravitate towards. Birgit and Nystrom invoked the Council of Europe's two principal instruments, the European Convention on Human Rights and, more especially, the European Social Charter, as a starting point for operating largely in exclusion mode, but with elements of reconciliation, above all concentrating on restoring the primacy of core labour rights. Then my fellow panelists took up this discussion, particularly in the location of ECJ case law, Petra concentrating on, as I did, on the Kunston case, Sophia wondering about the possibilities for further judicial development, and Ulf returning to what I like to think of as a very long-running dialogue between us as to the underlying potential for adaptation of EU jurisprudence in this crucial sphere. We were talking really about whether the Court of Justice has gone into reconciliation mode in a positively social law sympathetic manner. Hard to say. This is very much a game still in progress and being played out. We hope that this morning's discussions have confirmed our hypothesis that there is a continuing and crucial dialogue between EU law and national labour law systems in this absolutely critical area. I'm sure I can say for Jeremias, as for myself, that we have been enormously grateful for the interest that has been shown this morning in the set of ideas which we've been trying to bring forth in cooperation with our many enormously able colleagues and contributors. We're especially grateful for the quantity and quality of this group of colleagues and participants in this morning's seminar. I was reflecting as we came into the room that we had to come to Stockholm for this, and I feel strongly that we would have had to be extraordinarily lucky to have this degree of interest and this quality of discussion in any other place. I have to say that we'd have been most unlikely to get it in London. So I want to conclude with a big vote of thanks from Jeremias and myself and the other contributors to the TOC, Samuel, and this essentially Swedish audience. Thank you very much indeed. We have greatly valued this opportunity. Thank you.
Well, and thank you, Mark, for these sort of final reflections. I think you wonderfully summed up this morning, and you, as always, you pointed out. I think you found sort of qualities in our arguments that we didn't know of ourselves. So. I would also like to thank all the authors, the commentators, the panelists. I have a small token of appreciation here, some kind of magic pen that I don't really know how it functions. I would also like to thank the audience for being here. Most of you have been here all day. I hope that it has been useful and interesting, and that you can will be some knowledge here that you can apply in your future work. Buy the book, I should say that. Also, this seminar will be on the TCO website shortly, so you can watch it there. If there was some subtle point you want to recapitulate, and you can watch it again. So thank you very much. Thank you for coming, and I hope that I will meet most of you people soon again in our various functions. Thank you.